My name's Chip Pickering, and I'm the CEO of NEPA. I want to welcome everyone to a very timely conversation and discussion with someone who can give us probably the most accurate insight into a new Supreme Court precedent called we're titling our conversation today, the new NEPA, after the precedent-setting case that came out of Seven County Infrastructure Coalition versus Eagle County. Jay, this is a very timely conversation. Most of our member companies are building the infrastructure of AI, whether that is the fiber networks, data centers, and energy networks, grid, transmission, pipeline, generation. So all forms of infrastructure deployment that is critical of winning the race to AI dominance and energy dominance that the administration has laid out really rest in many ways on how fast we can deploy the infrastructure. And we've been advocating for a number of years on streamlining the permitting process, the environmental, the regulatory reviews, so that we can have an opportunity to build and deploy capital as quickly as possible. To give everyone a little bit of a background on Jay, he serves clients in a wide range of infrastructure and natural resource contexts, both by guiding them past regulatory and environmental review obstacles to win agency approvals and by litigating the complex issues that often arise in such contexts. Jay focuses on projects that attract scrutiny from both regulators and third-party groups, including mining, rail, and surface transportation and port projects. He's briefed and argued dozens of cases in trial and appellate courts around the country and has successfully petitioned for U.S. Supreme Court review as counsel of record in Seven County Infrastructure Coalition versus Eagle County. And this is the case where the court will hear during the October 20 that was heard last October, now setting the precedent. And so we look forward to hearing his insight into what is next in the regulatory agencies, how they reset their interpretation of NEPA and the NEPA process, and can give us all great insight into what we think can be winning strategies as we try to build the infrastructure. So Jay, welcome, and I look forward to the conversation today.
Thank you so much, Chip. I really appreciate that kind introduction. And I appreciate the opportunity to come today and talk to everyone here about the Seven County infrastructure case. I've got a presentation that I'm going to take you through to explain kind of the background of the case, what the court decided, and then where we think it's going to go. And at the end of the presentation, I'm very happy to answer questions. I think there's a Q&A box at the bottom of your screen. If you're on Zoom, you can just type a question into there, and when we get to the end, there will be time left, and I'll take as many of those questions as I can. So with that out of the way, let's get started. I'm going to share my screen here. Okay, I'm going to start with what I think is a pretty great picture. Anytime you can start a presentation with President Richard Nixon signing a bill, it's an exciting time. And he's on here not just randomly, but because President Nixon is the one who signed the National Environmental Policy Act. It was among the first of the big environmental laws that was enacted by Congress and signed by various presidents in the 1970s. It even predates the Clean Water Act revisions. It predates the Modern Clean Air Act. NEPA is kind of the grandfather of all of it. And that's relevant because NEPA is different from a lot of those other laws. Those laws oftentimes impose substantive, rules about how to behave, but NEPA is really a procedural statute. All it really tells agencies to do is to prepare a, quote, detailed statement to catalog what the environmental effects of their actions are going to be. And to compare those effects to the effects of a reasonable range of alternative actions. It doesn't tell agencies not to take an action that harms the environment or that it has to take the least harmful action. Its only message is categorize, collect information, and put it in a report. And that's where I think the Supreme Court's opinion in Seven County really begins. But before we get to the opinion, let me just tell you a little bit, because it's helpful for background, about what the case is as a purely factual matter. The Seven County Infrastructure Coalition case is about a new railroad in the Uinta Basin, which is this really large, really rural, and really inaccessible part of the state of Utah. The Uinta Basin is bigger than the state of Maryland, so it's a really large area, but there are only 2-lane roads over these high mountains to get there. The reason a lot of people want to get there, other than the people who live there, is because there are tons of natural resources in the Uinta Basin, including waxy crude oil. The idea behind the Uinta Basin Railway, the project that's at issue in the Seven County case, is to bring that oil out of the basin using rail instead of the way it's brought out now, which is large tanker trucks that have to be heated so that the oil won't congeal while it's being driven to a refinery. If the rail is built, then the oil in the basin can be moved to the national rail network, and then it can be sent to refineries anywhere in the country. So the backers of the rail line include our clients, the Seven County Infrastructure Coalition. It's 7 counties in Utah that are just trying to make economic life better for the people who live there. So to get the Uinta Basin Railway approved, we had to go to the Surface Transportation Board. Now, this is an agency that's perhaps unfamiliar to a lot of people. The Surface Transportation Board is actually, though, the oldest independent agency in the federal government. It was created in 1887 under the name Interstate Commerce Commission. And its job then and now is to kind of regulate the economics of the railroad. And as part of that job, the Surface Transportation Board will approve the construction and operation of new rail lines like the Uinta Basin Railway. So in this case, we took the proposed project to the Surface Transportation Board. The board performed a NEPA review, and that led to a 3,600-page environmental impact statement that we really thought was the gold standard, both in terms of how efficient it was, it took about 2.5 years, and in how comprehensive it was. Some agencies can take twice as long to do an EIS. We were at the time pretty pleased with 2.5 years. So, that seemed reasonable to us under the old NEPA. But as you'll see, things are going to change. So once the Surface Transportation Board made a decision approving the Uinta Basin Railway, the people who don't want the oil to come out of the basin, people who don't want the project to be built, they filed a challenge in the U.S. Court of Appeals for the D.C. Circuit. Now, it's very important to note that the challenge they filed really didn't have anything to do with the impacts of the rail line itself. What they were worried about and what they argued about in the DC Circuit was upstream impacts, they called it, which meant, well, if you build this rail line, there's going to be a lot more oil wells drilled. What about the impacts of those things? And then they also had downstream impacts, which meant when you ship this oil on the national rail network and it goes to a refinery, say in Louisiana or Texas or Washington State, well, then there are going to be emissions from that refinery. And what about those emissions? Aren't they going to hurt the people who live in Louisiana and Texas and Washington State? And then there were what's called downline impacts, mostly in this case related to the potential for an accident as the trains on the National Rail Network carrying oil from the Uinta Basin go through places like Eagle County, Colorado. The people who lived there thought, well, what if there's an accident in our county and there's an oil spill? Shouldn't that have been studied in more detail in the EIS? Now, we argued in the DC circuit that those things all were studied as much as they possibly could have been based on the information we had in the EIS. But the DC circuit judges disagreed, and they basically said, well, you may have looked at some potential for new oil wells, some potential for new refining, but you didn't dive deeply enough. You need to study more. And they sent everything back to the Surface Transportation Board for what to us seemed like it would be years more study and then years more of litigation. And that just wasn't going to cut it for us. And that's why we tried to take the case to the US Supreme Court. So when we got to the US Supreme Court, we were able to present the court with the real problem with NEPA. And I think the court really got it. And the court framed it in this way. It's like a vicious cycle. When courts engage in what the Supreme Court called overly intrusive and unpredictable judicial review in a NEPA case, and they send something back that has 3,600 pages of analysis in it, then that makes agencies worry about the next time they do an environmental impact statement. And they take more time. And they think basically, well, if 3,600 pages wasn't enough, next time it'll be 4,600 pages. 2.5 years wasn't enough time. We'll take 3.5, 4.5. And this has been happening for 20 years or more. And that's why, at least up until this case, going through the NEPA process was, by and large, a nightmare for project developers. You didn't know how long it was going to take. You didn't know what impacts the agencies were going to make you study, and you didn't know what was going to happen when you got to court. Yes, the agencies were doing their best for the most part, but there was just so much uncertainty. And the Supreme Court realized that, and in Seven County, I think they are trying to solve that problem. So what did they do? Well, the first and most important thing, at least for our clients, is that they reversed the DC Circuit's decision 8-0. No one disagreed that what the DC Circuit required was too much. But there was a division in sort of how much discussion the court was willing to have about the real problems with NEPA. And I think thankfully for people who want to build, there were 5 justices who were willing to write a really pointed critique of the way that NEPA has been handled. And I've put up in this slide a few of the big picture observations in the 5 justice majority opinion. NEPA is supposed to be a procedural. Remember, it's not a substantive requirement. It just requires you to do a report. NEPA is a procedural cross-check, not a substantive roadblock. And the majority also complained that there's too much speculation and consultation and estimation and litigation in NEPA. You know, that's just kind of a rhetorical strike at the heart of everything that NEPA has been for 20 years. And then the Supreme Court was explicit. It was trying to make a course correction that NEPA should not hinder projects with just a little more process, which is exactly what it's been doing for so long. So after this decision, I think a lot of things are about to change. You know, the first thing that's going to change is judicial review. The Supreme Court is very clear in its opinion that the central principle of judicial review under NEPA has to be deference to the agencies. And at the outset, I think I'll clarify, because there was another case just about a year ago that talked a lot about deference to agencies in a slightly different context, and that's a case called Loper-Bright. What Loper-Bright did was to overturn the idea that courts had to defer to agencies on how those agencies interpreted statutes. Whereas here in our case in Seven County, what the Supreme Court is saying is that courts should defer to agencies when they're using their technical or scientific or factual expertise to make a decision. So I think that can be a subtle distinction sometimes, but I like to think of it like this. When you have a question that you would go and ask a lawyer to answer, that's a Loper-Bright question, and there's no deference to agencies. Agency lawyers aren't any different from any other lawyers, and they certainly aren't different from judges. Judges get to decide those legal lawyer type questions. But when you have a question that you would go and ask a consultant about, or you would go and ask a scientist to answer, those are Seven County questions. Those are the kind of questions where agencies should get deference. And so, for example, if an agency and the agency scientists say, we've looked at this train and we believe that this train is going to emit, X tons of carbon monoxide into the atmosphere, then you may have people out there who disagree with that. You may have environmental groups who think, actually, no, it's going to be more than that. But the court is not going to try to parse that question. That's a scientist question. That's an expert question. That's a factual question. That's the kind of question where Seven County says, defer to the agencies. So all that to say, when you have a NEPA case, and it's almost entirely about the science and the environmental impacts of a project, the agency decision ought to get deference. Similarly, when agencies are deciding what to study under a NEPA review, how many alternatives to look at, how far down the line to go, again, they get to decide that because agencies need to make decisions on the merits of a question. They need to decide whether or not to issue a permit. And when the agency is deciding whether or not to issue a permit, it's in the best position, to decide what information is going to be helpful in its decision-making process. Another really important piece of the Supreme Court's decision is in this third bullet here. The court just says flat out, brevity should not be mistaken for lack of detail. The court wants shorter environmental impact statements. 3,600 pages to the Supreme Court was mind-blowingly long. To a person who does NEPA all the time, like me, it was an average NEPA review. I've seen way longer ones, but the Supreme Court could not wrap its mind around that idea. 3,600 pages to a judge is way too much. And that's why they have this point. It's okay to be short and sweet. And then finally, the court makes the point that the ultimate question in any agency permitting context is the final decision. Is the permit reasonable and reasonably explained? And the NEPA is only one piece of that final decision. And the court is very clear in Seven County that because NEPA is only one component of a final decision, if there is a flaw in the NEPA review and it's not major, courts should even consider excusing that and just saying, even though there are some problems here, the overall decision is reasonable and reasonably explained, and we're going to uphold it. That's something That's never really happened in NEPA world before, and I'll be curious to see if some lower courts take advantage of that opportunity. All right, so let's think about the other side of the cycle. The first side of that vicious cycle that was in an earlier slide was overly intrusive judicial review. The other side is agencies reacting to that by taking longer and writing more in their NEPA reviews. How is that going to change? Well, the first way, I think, is that agencies are going to start taking a lot more seriously the timing and page limits that Congress put into NEPA a couple of years ago. And those limits say that if you're doing an environmental impact statement, which is the most thorough kind of NEPA review, it has to be done in 2 years and it has to be no longer than 150 pages. If you're doing a lesser level of environmental review, it has to be done in 1 year and 75 pages. Now, I think before 7 County, this really would have been incomprehensible. And again, these limits were in place, but agencies were basically just ignoring them because the litigation risks were so high when you wrote a short, quick NEPA review that they just wouldn't do it. And now there's a chance, I think, with 7 County to make these limits real and to actually have NEPA reviews that are done in less than 2 years and in 150 pages. How else will the process change? Well, I alluded to this a little bit earlier, but agencies have the freedom to decide what facts are relevant to their decision. If an agency wants to build a new railroad, as in our case, does it care what's going to happen 500 miles away in Colorado, or is that not really relevant to its decision? If the agency decides it's not relevant, it doesn't have to look at it as long as it explains why it's made a decision. Sort of an even brighter line in the Supreme Court decision. You don't have to look at potential future projects or geographically separate projects. This was explicitly directed at the possibility of more oil wells or more refineries that came up in the context of the Uinta Basin Railway. The Supreme Court's decision in 7 County has ruled out the study of potential future projects or geographically separate projects. It's saying, if your new project, your railroad might trigger more oil wells, you don't have to worry about that. Some other agency, a state agency, a federal agency, a local agency, those are the agencies that approve new oil wells. You can let them do their job and you don't have to worry about that potential future consequence of your project. And I think that's a huge change in NEPA. Another sort of related change, agencies don't have to study projects that are outside their regulatory authority. The Supreme Court's decision says the Surface Transportation Board's job is to approve railroads. It's not to approve oil wells or refineries or a lot of other things. And the same kind of logic can apply to other projects. And then the last and maybe most flexible thing that the Supreme Court does is say agencies are allowed to draw a manageable line around their environmental review. This is a very pragmatic rule. Agencies have to get this done in 2 years, in 150 pages. Sometimes they're just going to have to say, we can't study that in so much detail within the time allotted. And the Supreme Court is basically saying, that's okay, you should do that. So now we step back and say, more broadly, what is the court's policy message here? This is not limited to new railroad projects. This applies to NEPA as a whole, and the court made that exceptionally clear. There's 2 quotes in particular that I think are really helpful and that I plan to be using every time I have a NEPA review from here on in. The first one is that NEPA has transformed modest procedural infrastructure projects. The Supreme Court doesn't want that to happen anymore. And then there's sort of a little bit more colorful language a few paragraphs later, which is the reason for this picture of the oak tree. A 1970 legislative acorn has grown into a judicial oak. Well, I think the Supreme Court was here to chop that oak down. And I don't think it could have been much clearer that that was its intent. So how have people reacted to Seven County? Well, it certainly was in the press portrayed as the Supreme Court wants to make it easier to build. A permitting revolution, one headline said. I think that's right. I think that's the right way to think about the Seven County case. The Supreme Court recognized not just a problem with an 88-mile rail line in Utah. The Supreme Court recognized a problem with the way that NEPA has been operating for the last 20 plus years. And it, again, to language that I already quoted, it made a course correction. It said, this isn't good enough. We need to do things better and to let things in this country get built. There's a long passage in the opinion. It's too long for the slideshow, but it's essentially the Supreme Court saying, because of NEPA, fewer projects make it to the finish line. And it's just such a slog that people can't even get their projects to a yes or no decision. They just get bogged down in NEPA forever, and either the project runs out of money or the agency, runs out the clock. And the Supreme Court also points out fewer projects get to the starting line because everyone knows what a slog NEPA is. Some projects never even try. They just know that it's not going to be worth it to spend 4 or 5 years and millions of dollars doing an environmental review for a project. And the Supreme Court says that's not how it should be. That the result of that is less building, fewer jobs, and a smaller economy. And the Supreme Court, at least the 5 justices who wrote the majority and whose opinion is now the law, they said no. Okay, so you've got Seven County. What else is happening? Well, after this is the president's Council on Environmental Quality. That is sort of the White House NEPA monitor. And the White House NEPA monitor has told all of the agencies that they need to put out new NEPA procedures. And those agencies have been acting relatively quickly. In July, a whole slew of agencies came out with new NEPA procedures. That included the Defense Department, the Corps of Engineers, part of that. That's a big NEPA agency. The Department of Transportation, the Department of Commerce, the Department of Energy, the Department of the Interior, and FERC, the Federal Energy Regulatory Commission. All of those agencies have new NEPA procedures as of July 3, I believe. And there's a lot of commonalities in those procedures. There's more emphasis on categorical exclusions. Those are categories of projects that just don't even require NEPA because they're generally understood not to have significant environmental effects. If you fall into that category, you can skip over NEPA entirely. There are stricter page and time limits consistent with what we discussed earlier. 150 pages for an EIS, 2 years for an EIS, and 1 year and 75 pages for an environmental assessment. There's a greater focus on what the Supreme Court called the action at hand, or the project at hand. Just focus, the agencies are saying, in line with what the Supreme Court said in Seven County, focus on the project that applicant has brought to you, consider its effects, and you're done. You don't have to go downstream, upstream, downline. You need to focus on what the effects of your project is and let other agencies who have other jobs and other regulatory jurisdictions worry about their own projects. And then I think maybe most interestingly, in the long run at least, there are procedures in all of these new rules for applicant prepared documents. That would mean, in theory at least, that the person proposing the project could prepare its own environmental impact statement, submit it to the agency. Of course, the agency is going to have to review it. It likely would have lots of questions. But I think in the longer run, this could be a very efficient way for applicants to get through the NEPA process once they persuade agencies that they're going to do a good job and that the agencies can rely on the information in the applicant prepared document. Okay, so last slide, and then we'll take some questions. What is the future of Seven County? What is the future of NEPA? Well, I think that it's important to sound a little note of caution here that sometimes it's easier said than done when it comes to new Supreme Court decisions. 2 years ago, the Supreme Court issued a decision called Sackett against EPA. It was about the scope of the Corps of Engineers jurisdiction under the Clean Water Act and whether wetlands in particular are federally jurisdictional or not. And the Supreme Court wrote a decision that is probably at the same level of force and clarity as Seven County, saying essentially the Corps has exercised way too much jurisdiction over wetlands for 20 years. But here we are 2 years later, and I am sorry to report that there has not been a great deal of change in that regard. Now, maybe that's going to slowly seep into the Corps' systems. Maybe there will be more change in this administration than there was in the last one. But what the Supreme Court says doesn't automatically become reality on the ground. And so I think the future of Seven County is going to require some work by the people who are applying for projects, construction projects, infrastructure projects, all sorts of projects, and some work by the agencies in thinking more creatively and not being afraid to rely on what the Supreme Court said in court. And, part of that is knowing what these new procedures say, finding ways to apply them, and recognizing that every case is different. The problems that were in the NEPA review for the Uinta Basin Railway in Seven County aren't going to be the same kind of problems that affect other projects. And you're going to see people who oppose construction projects out there saying, well, this isn't exactly like Seven County, so, Seven County doesn't apply. Well, that's not what the Supreme Court intended, in my view. And I think it's going to be up to project proponents and their consultants and lawyers to explain to the agencies how Seven County applies under different circumstances. And then, of course, there's always going to be complicated projects where you need to go up the agency ladder, so to speak. Sometimes people at the local level might not be as aware of what's happening in the Supreme Court, and you may need to appeal to a higher authority. I think that's a very important way to implement Seven County. And then last of all, especially if you're dealing with a large or a controversial project, you're going to have to be prepared to defend it in court. And that's part of it. Inevitably, the Supreme Court can't prevent people from suing. It can only change how those lawsuits are evaluated. And it did that. Now it's going to be up to the people who are litigating, including the agencies and the project proponents, to make the Supreme Court's decision real. So that's the presentation that I was planning to give here. I'm going to stop the sharing. And if people have questions, I'm happy to take them in the Q&A box. I'm happy to just talk through things. But I'm here for as long as you guys would like me to be here, and happy to discuss any questions you might have.
Hey, Jay, this is Chip again. And I was going to ask for our member companies, if they're doing a energy project, whether it's a pipeline, a transmission, a grid, a fiber route that crosses multiple jurisdictions, a data center, as they look at the NEPA process now, for those types or for the industry that Encompass represents, can you kind of talk through what you gave the rail example? Any insight or context on the infrastructure that we're talking about and the member companies that we represent?
Yeah, that's a great question, Chip. Thank you for asking. So I think there are different agencies that regulate different types of things, as we all know. If you're doing a pipeline that's regulated by the Federal Energy Regulatory Commission, then I think that's one of the agencies that's going to be very ready and willing to be aggressive in applying the 7-county case. A lot of the FERC pipeline cases in the DC Circuit were the reasons we got the decision we got. The DC Circuit had been pretty aggressive in striking things down in FERC, and I think since 7-county, you're already starting to see a little bit of change with that. If you're talking about other agencies that have to regulate, then it could be a slightly different question. I mean, I think one thing I didn't really talk about as much in the presentation, but that's something we should remember is, a lot of projects require multiple agencies to approve them. And 7-county is no different. The Uinta Basin Railway has to be approved by the Forest Service too. And when you've got one project that crosses multiple federal agencies, it's always best to have one review that covers all of the effects of the project. What you're trying to avoid with 7-county is somebody saying, well, if you're going to build a pipeline over here, and in the future, someone else is going to build a data center that's going to take advantage of that energy or that fiber optic or whatever it might be, we need to study that future data center in your environmental impact statement. I think after 7-county, you can say, no, this project is just the pipeline or just the transmission or whatever. And when somebody wants to build a data center down the road, or even if the same people want to build a data center down the road, you can say, when we need that data center, we'll go and get the approvals for that data center, and we'll do the NEPA for that data center. And it enables you to keep each review focused, especially when you're dealing with something that's maybe uncertain in the future, or depends on future investment or things like that. I think there's been a lot of times when NEPA has required too much speculation about what might happen someday, and that can get you really tied up in knots, and we're trying to untie those knots now. Did that help answer your question, Chip?
It does. And let me ask a question about multi-agency review, and if there'll be any, do we need to have legislative action that would consolidate reviews? And let me just give you one example. There's a project in Mississippi where the USDA Forest Service did a NEPA review for a transfer of property from a Forest Service to a nonprofit regional economic development group.
Mhm.
Same land, same place, received a grant from HUD to build a road to the site where a new project will be built. But because there's a different agency, but same property, same issues, same environmental issues, they had to do a second environmental review, even though it's not, nothing has changed, and it's the same piece of property. Well, those types, do you ever see a day where there'll be one review that will be sufficient for multiple agencies versus multiple agencies having to do their own NEPA review?
Yeah, I mean, that should be already today. Like that when NEPA was amended, it added some language about consolidating environmental reviews in just the way you're talking about. So I could see that going two ways. One, you bring HUD and the Forest Service together and they just do one review that covers everything and they can both rely on that review. The other thing that could happen is once the Forest Service is finished, if HUD's not ready to make a decision or to do its review, it should be able to say, well, we have to check the NEPA box, so to speak, but there's already a review out there for this same thing. So we're just going to use that. Maybe we need to add like, a page or two to cover something that's slightly changed or whatever, but you should be able to both combine reviews when all the agencies are ready and rely on older reviews if you're dealing with something that's the same.
So, and that's under the existing precedent and practice.
It should be that way.
Our member companies should be able to do that.
They should be, but it's like I said toward the end of the presentation, there's a matter of, how things should be and how things are, and agencies are too often stuck in like old ways, old NEPA.
Yeah.
And part of our job is to help them see, oh, look, you didn't have to do that. The law says you can do this, and we want you to do that. We're pushing you to do that. I think sometimes agencies need that push.
This is very helpful. Thank you, Jay.
Great. I'm happy to help. There are a few questions in the Q&A thing now. One question is whether the 7-county decision will dampen efforts at congressional levels. I don't know. That's not my area of expertise for sure. I've still seen a lot of talk in the press about permitting changes in Congress. So I don't think that it's going to dampen things for sure. I would look at it as kind of a both and situation. It doesn't hurt to keep going with congressional things, even if they're a little redundant to what the Supreme Court said. But if the congressional efforts don't make it all the way through, then you still have 7-county and the new NEPA procedures from the agencies to fall back on. Next question is, how might wireless development be affected? I think a lot of the same principles would apply. It again depends on the agency that you're dealing with when you're building your wireless infrastructure. But the Supreme Court is 100% clear in 7-county that NEPA shouldn't be used to stop or slow down construction and infrastructure development. And that's basically anything that would involve NEPA in the first place. So if you're getting pushback from an agency on a wireless job and they're slowing things down, or they're doing too much, or they're looking at effects that aren't really predictable, then you can definitely point them to 7-county and say, look, you guys you're not listening to what the Supreme Court said. And the last question that I have right now, do I think that the language and tone of the case might encourage agencies to expand categorical exclusions? That's a good question. I mean, for sure, the administration wants to expand categorical exclusions. Like, that is undoubted. I don't think 7-county has anything specific to say about categorical exclusions, but if you're talking just purely on the level of language and tone, then yeah, I mean, again, the case is ultimately the Supreme Court saying, what are we doing with NEPA? Why is this such a problem? And one solution to that problem is categorical exclusions. My only caveat there is, if you apply a categorical exclusion and someone can show that there actually are significant effects to your project, there's probably still going to be some litigation risk there because 7-county doesn't explicitly address that issue. So I think maybe going forward, there's going to be a bit of a balance. Do we want the categorical exclusion and just get started immediately, or maybe we do an EA that takes 9 months and we get it done that way, and we have a little more defensibility in court. I think that's going to be the balance, and part of the question is going to turn on, how much opposition is there? What's going to be the risk of litigation if we take the categorical exclusion, or is it just one of those things where no one's really objecting? There are a couple more questions now. I'll go ahead. Let me see. Oh, yes, this is a good one. It's talking about how there are sometimes when an agency doesn't begin its own shot clock until all the reports submitted. Basically they say, oh, well, we know we have to have this done in a year, but we're not going to start counting until 2 years from now. Maybe it's not that extreme, but essentially they're gaming the timing by either waiting until something is submitted, or I'm aware of one where they basically say, well, you can't even submit your application until the NEPA is done, and we won't start counting until the application is submitted. I I don't think that kind of stuff should still be happening. I do think sometimes the question suggests rightly that revised agency guidance could address that. I think it will sometimes. I also think there are going to be times where you might have to go up the ladder a little bit on problems like that, or just even, have direct push against an agency. We can't wait for this. We can't. This is contrary to what the procedures say, contrary to what 7 County implies, contrary to NEPA statute. That's where the time limits are. So yeah, that can definitely be a challenge. I think in this administration, there should be options to push back on it, but every situation is different, and I definitely think this is an issue. Any thoughts on the FCC's proposal on NEPA in light of the Supreme Court's decision? I don't know if I have any specific thoughts about it right now, but to the extent that an agency is, well, I'll say this. I think all the agencies are aware of 7 County. All of the new procedures cite it in their sort of preambles. And it is, if one of them is doing something that isn't consistent with how we read 7 County, then it's worth the discussion, because the procedures, the new procedures that came out, and any new proposals, they are open for comment. Although I think the comment period closes next week on the ones that came out on July 3rd. There's an opportunity to say, oh, you shouldn't start the clock at this time. You shouldn't do X or Y because that's not consistent with 7 County. I think the agencies will listen if that's part of the discussion. Okay, well, I think that's all the questions I see. It was a great pleasure to be with you all today. Thank you again for having me. If you have any questions, I'll just throw up my number again one more time, and my email should be here too. I just put it up on the screen. I'm very happy to talk to anybody who is having a NEPA question, who wants to ask about 7 County more generally. It's I really think an opportunity for this industry and for every industry to stop having things be blocked by environmental review, and instead have environmental review be a proper consideration as part of a decision on a permit, not the roadblock that it has been for too long. All right. So again, my pleasure to be here. And I think that it's my job just to close out the whole webinars. Thanks again, and I hope to hear from you.